Well, Mr. McLeod, it's alleged that you are in contempt of court for failing to appear on July 9th at 9:30 a.m. for a 50-page circuit court hearing. You've got the right to a hearing on that allegation where it would need to be proven beyond a reasonable doubt, and the right to the assistance of an attorney at that hearing. If you are found to be in violation, if you are found to be in contempt, I could jail you for up to 93 days. I could fine you for up to $7,500 or both. I can also revoke your bond if you're not complying with the terms of your release. Do you understand the rights and penalties that you have in front of you, Mr. McLeod?
Sure. I was under the impression that this was all going to be over with by now. That we're
Nope. Nope. All right, Mr. McLeod, and also, so you know the rights and penalties that I outlined for you. You understand those?
Yeah.
All right, Mr. Varga, do you know how he wishes to proceed?
No, he indicated he would enter something.
Mr. McLeod, you're indicating you want to represent yourself?
Well, I thought that can I say a couple things first?
No.
Okay.
You can answer my questions.
Sure.
Are you saying you want to represent yourself?
They have been doing that the whole time.
You've been doing that the whole time. Under Ferretta v. California, 1975, U.S. Supreme Court, defendant has the constitutional right to represent himself. He has, in this case, unequivocally asserted that right in prior hearings and validly waived his right to counsel. However, self-representation may be denied where the defendant disrupts, unduly inconveniences, or burdens the court and the administration of the court's business. That's 1976, Michigan Supreme Court, People v. Anderson. Even the Ferretta case, the U.S. Supreme Court said the right of self-representation is not a license to abuse the dignity of the courtroom. Neither is it a license not to comply with the relevant rules of procedural and substantive law. Here, while representing himself, defendant refused to accept mail from the clerk's office. When that happened, I directed staff to resend the mailing directly from the court, giving him the benefit of the doubt. Because he was representing himself, he would surely accept something from the court. He again refused, writing in red lettering on the envelope, "Return to sender," and offer to contract is denied. Defendant had someone file a document on his behalf in his case called a letter rogatory for relief, which was legal nonsense, accusing the court of fraudulently using this case as some sort of security against his trust, claiming that all judges are foreign agents and or employees of the International Monetary Fund, which is absolutely absurd, and demanding that he be placed on some non-existent do not detain list. This is not the first time that this defendant has disrupted this court's business. One time I had to hold Mr. McLeod in contempt for refusing to answer my questions during his initial waiver of counsel. After that contempt, we were able to complete the waiver process and I allowed him to represent himself. But at those subsequent hearings, he repeatedly interrupted the proceedings. He repeatedly persisted in arguments, even after being heard and ruled against. And now he has refused to participate in the court process by rejecting court mailings while purporting to represent himself. So I have now lost any confidence, Mr. McLeod, that you are able to represent yourself in this matter without disrupting the court's business or making a mockery of the court proceedings. Therefore, as this case moves forward, I am revoking your right to represent yourself, and I'm appointing Mr. Virgo to represent you as a lawyer.
Okay, let's just do Virgo here.
If the Office of Assigned Counsel determines that Mr. McLeod is not indigent or is only partially indigent, that office may petition this court under the applicable statute for contribution from Mr. McLeod for the cost of representation. So, Mr. Varga, you want us to set this for a hearing then?
I do.
All right,
Mr. Not guilty.
All right, Mr. McLeod will enter a plea of not guilty on your behalf as to the contempt. So we have to schedule this for a docket call on the underlying case, which is still pending, and on the contempt hearing. I'll schedule that for August 20th at 10 a.m. I also have to advise you, Mr. McLeod, that I canceled your jury trial date and gave that date to somebody else who was here. So your trial on August 8th and 9th will not occur. I will next see you on August 20th at 10 a.m. Anything as to release Mr. Varga?
Is the court wanting to entertain a bond on this matter, Your Honor? To my understanding, Mr. McLeod is a local resident and he has met, with the exception of the last court date, that he tells me that he thought the case was resolved, although obviously it was not. He has appeared for most of his prior court dates.
Oh,
Okay. And he's employed locally, Your Honor. I think perhaps if the court would set a modest monetary bond, that would ensure future.
I will not have to do. I assure you.
Mr. Juliet?
And I would ask that bond remain revoked. He is, what I'm told, rejecting the court's mailings of the notice to appear. I mean, I think that's just a blatant violation of
Can I speak on that?
the court rule. So he's made it clear he doesn't want to take this serious. I would ask that bond remain revoked.
All right, Mr. McLeod, is there something you wanted to tell me?
I wanted to speak on that, the mailing stuff. I do that with all my junk mail, and I'm really sorry if that happened to one of your letters.
Don't make it worse by lying to me right now, Mr. McLeod. You wrote clear things on that mailing that indicate sovereign citizen types of defenses that you thought you were asserting. It's not that this was junk mail. Don't make it worse. Don't make it worse by lying.
I apologize to you for maybe listening to some of the wrong information when I don't.
Well, you're a grown person, Mr. McLeod, and I hope you're learning an important lesson in civics.
Can I just say this?
You said what you wanted to say.
Before you make your decision, can I say this? I have a job right now that's completely exposed to the weather. I've got $40,000 worth of windows coming this week to this job. I really invested in this job, and my client really rely on me. This would be a really big problem if I get this revoked at this stage.
All right, well, Mr. McLeod, it's a shame you had to learn a civics lesson the hard way here. You are a citizen with rights and freedoms, but you also have responsibilities in a society where other citizens live alongside you. That includes obeying the laws that the people pass through their representatives. For example, the people are entitled to pass a law that says they don't want folks operating votes under the influence of alcohol. You think that law doesn't apply? It does.
That wasn't.
And when a law enforcement officer sees you violating that law, you can't resist arrest without consequence. When you are alleged to violate those laws, Mr. McLeod, there's a third branch of government that does exist. And it exists for the orderly resolution of those disputes, those allegations, with full protection of your rights, as opposed to some kind of vigilante justice system. You may not agree with this, but this court has diligently tried to protect your rights and afforded you a respectful and lawful process. You have disrupted and ignored that process. You have disrespected that process time and again. That subjects you now to contempt of court and revocation of bond. Most people, Mr. McLeod, learn this lesson the easy way, but it seems that you now have to learn it the hard way. You're remanded into custody of the Chagrin County Sheriff and will next see you, sir, with your lawyer, Mr. Wergo, on August 20th at 10 a.m.
What is your date of birth, Mr. Gray?
Good afternoon, Your Honor. 72 is my date of birth. I have a.
Can you say that again? Go ahead, say what you were about to say.
I have a motion before the court, Your Honor.
Let me first start. Do you need a lawyer, sir?
No, Your Honor.
City of Detroit versus Christopher Gray. State your name for the record, please.
Christopher Lamar Gray.
All right, today is the date and time set for a pretrial, and then there's warrants on the other matters. I'm going to enter a not guilty plea on your behalf. I'm going to give you a $0 bond. And I'll recall the warrants. What is your motion, sir?
I have a motion to strike and dismiss.
What are the bases?
Basis of federal rules of civil procedure. Number one, there's no claim. There's no ratification of the claim.
There is a claim. There is a. Do you want me to read out I waived the reading of the information. You want me to read the allegations that have been made into the record? Do you need me to do that?
No, I don't. No, I don't, Your Honor.
I deny your motion on that basis. What else do you have to say? What else?
You deny my motion because of what, Your Honor?
Yes.
There is no real.
I deny your motion because there is a and this is criminal procedure, not civil procedure. But I denied your motion because there is an allegation here.
You're saying, Your Honor, you're saying this is a criminal matter?
Yes.
Okay, well then we need the corpus delicti. And so that's what I'm asking for. If there was a criminal matter, basically what you're telling me is that something has happened, someone has either been damaged or someone has been or either someone has been damaged or someone has something has been come up missing. And if that's the case, then that means that there is a crime. And if there's a crime, then there is the what do you have that's saying that I did the crime? What you're saying that I created this crime that hurt this person, and if I hurt this person and I created the crime, then a third thing that you have to have is the identification of the person. You have the identification of the person, which is me, but you don't have a person saying that they were hurt or damaged, or the crime that's saying what I did to hurt or damage the person. So how do you have a crime?
Okay. You went to law school?
No, Your Honor, I have not.
And where did you get that from? Where did you learn all that?
I've been studying for quite some time, trying to understand what's going on. I have a different perspective as to what's being said that happened. I'm understanding more the procedure that is necessary for a crime to go for them to bring a crime forward. I'm understanding that a bit more.
And where did you get that understanding?
I've done some Cornell law studies. I've also sat down with a couple of friends who have had some issues. I picked up wherever I could, just started to study the law. I just started to go back through Cornell law, started to figure out what was going on and to understand the nature of how what a crime is and everything else. So just a course of me searching it out.
And you're citing Cornell law for all of that you just said to the court?
No, what I did, Your Honor, was I realized that one of the biggest portions that you have to have is the corpus delicti. And that is in when you're being charged criminally.
What is the corpus delicti?
What do you mean, what is the corpus delicti?
What is your understanding of what corpus delicti is?
That is the corpus delicti is the law that's saying that there is a crime that's being committed. So in order to do that, you have to show the corpus delicti, which is you saying this is what happened. This is how this person was damaged.
So
there is no
the
person.
Officer on these dates, because I got a lot of them, said that
I object. I object. The officer works.
Don't interrupt me.
I apologize, Your Honor. I apologize, Your Honor. My apologies.
The officer says that you drove a vehicle that wasn't registered and wasn't titled, or titled and or untitled, that you drove without a valid driver's license, that you drove without valid insurance. Again, on a different occasion, they allege that you drove without a valid driver's license and no insurance. And then on a different occasion, they allege that you drove without unregistered or untitled or both, and drove without a valid driver's license, repeat offender, that you failed to have a trailer plate, and that you failed to secure a load on your vehicle. And on another occasion, on the same occasion that you failed to secure, that they allege you failed to secure the load, failed to have a trailer plate on your vehicle, that you didn't provide a valid driver's license. So those are the crimes. And in state of Michigan, whether you agree or not, they are crimes. So based on your motion and all of that stuff you talk about, corpus delicti and things like that, the court denies the motion, okay? Based on those reasons that I just said. Now, how do you want to move forward? Because wait a minute, I'm not finished.
My apologies, Your Honor.
How do you want to move forward? Because in my experience, someone that comes into court, as you do, you do not want to take an offer. You do not believe that you need to have plates or registration or insurance, and you just disregard all of that portion of the law. And either you are going to move forward by having a trial, or you're going to take a deal. What do you want to do, sir?
Your Honor, first I want to put my objection on the record. And at that point,
whatever your objection is noted. What do you want to do, sir? Do you want a trial? You have two options: trial, or you want to take a deal.
Your Honor, I request a jury trial.
A jury trial.
A jury trial, yes, Your Honor.
Very good. Mrs. Mathis, I need a jury trial date. Please.
And if I may, Your Honor, what time is Mr. Gray presently docketed?
I don't even think it matters, but I'll tell you. I don't think it matters. He's got the newer cases and the older cases are pretrial at 8:35, Christopher Lamar Gray, and then he had some in warrant status. I counted 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 cases into the record. You know what I want to ask, Mr. Gray, and you can choose to answer it or not.
Yes, Your Honor.
But what I surmise and what I've heard, and I don't know if you're alleging the same thing, is that and you basically did allege the same thing, that no crime has been committed because no person has been, the people of the state of Michigan are in danger of you driving without the proper documentation or anything like that. But I don't, and I'm gonna surmise, and you can correct me if I'm wrong, that you're gonna say that there's no jurisdiction to be able to pull you over because no one has been injured. Is that correct?
I think that what I'm saying is that the city of Detroit had an officer pull me over to say that you're not following these rules. And my stance is, okay, well, then that's fine. If we're following rules, then therefore, let me make sure that you as well as are following the rules, because if I don't do that, then freedoms are lost. So that is that is the way that I proceed, to say, okay, well, then if we're playing cards and we playing show me yours, if this is your hand, then this is mine, and let's proceed accordingly to the law. That's it. That's my only standing, is if someone doesn't stand up every once in a while and define the edges, then they all disintegrate and people lose rights.
And you know something? With that being said, I would agree with you 1,000%. That's why I pride myself, and I hope I'm doing a good job for the citizens that come in here, and the police for that matter, and the prosecution, that I am calling the balls and strikes right. And if something doesn't proceed as it should, then I will dismiss the case one way or the other. But in my short time on this bench, and in my time at practicing law as a defense attorney, I get this, they can't pull me over. I've heard the corpus delicti, first time the civil procedure has been thrown at me. But from the way I see it, is that you just don't feel that the police have a jurisdiction to pull you over for these issues. Is that correct?
Do I have again, Your Honor, what I feel is that if we are following rules, that if I have to follow the rules, and every person out there, all of these officers, everybody else has to follow the rules. So if it comes down to it, what I'm going to hope that you do
by the time you come back on the trial date, jury trial date is going to be March the 18th, 2025.
Thank you, Your Honor.
You're probably going to have an audience because everybody follows me on these cases all the time.
I understand.
All right, and I don't know if that's what you want, but we're gonna do that.
It's not that.
March the 18th, 2025. We're gonna have a final pre-trial date. Final pre-trial. This is to you, Mr. Bowman, especially the day before on February 17th, 2025 at 8:30. So Mr. Gray and Mr. Bowman, Mr. Bowman, I need you to have all your officers appear on that date. Who's ever going to state these allegations, so that we know that we're not just summoning the people of the city of Detroit to a jury that's not actually going to go. So all parties must appear, and that can be via Zoom. And the trial is going to be in person. All right. All parties must appear on final pretrial date and obviously on the trial date. And what I would implore you to do is you need to figure out the right game, because it doesn't sound like you're playing the right game.
I understand, Your Honor. I appreciate, first and foremost, let me say, I appreciate the dialogue. I appreciate you sitting here and engaging with me at this level. So I recognize what you're saying, and so I guess it's to the table we go. So
yeah, but get your game in order, because I'm just giving you a little heads up. If you come in with that game on the jury trial date, then more than likely you'll lose, unless you can find one of those jurors or a couple of those jurors, or even all of them, to have some sympathy for you, sir. I don't know.
I got a whole basis for understanding, and so yeah, if you know it.
Well,
it
that
is
basis that you outlined shortly today is not.
What was flawed in my what was flawed, Your Honor? What is
we
flawed
already
in
discussed
my?
it. We already discussed it. The federal rules of civil procedure that you brought up as a motion to dismiss, not the right basis. The corpus delicti, they do have a corpus delicti. They do have a crime that they say has been committed. And if you read the MCL, the Michigan court rules, and the Michigan statutes, then you'll see those crimes outlined there. They have them on the tickets. They got the statute numbers that are on the tickets. So that's not the right basis. So you're in a whole different ball game, and you need to come on to this ball game here.
Okay. All right. Okay. Well, I guess we will have that discussion again. I appreciate it. I also want to say I recognize and honor your compassion that you sit on the bench with. I see it as you go out here and you judge our people, and so for all of that, kudos, man. That's for where you sit. I appreciate that. Thank you, sir. Appreciate it.
I appreciate
Yes,
that.
sir.
Mr. Gray,
Yes, sir.
you have a
Yes,
safe
sir.
happy holiday season, sir. And
You as well.
best of luck to you. I'll see you back on March the 17th, 2025 at 8:30 for a final pretrial. And let me say this, let me add to
Yes,
the record.
yes, Your Honor.
If there's any motions, those motions need to be in writing.
10 days, within 10 days.
Let's put that on the record to a motion. Those motions need to be in writing. Have those motions to the court by February 14th, 2025. And the response will be February 21st, 2025. And I'll rule on those motions on the final pretrial date of 3/17/2025. Again, all parties must appear, Mr. Baldwin, all right?